Good evening, everyone. Can I have your attention for the beginning of the event tonight? So very good evening to everyone here. Welcome to the Asser Institute. For those of us in the room, thanks for making the journey on this very cold Thursday evening in January. And also welcome to those of us joining online. My name is James Patrick Sexton, and I'm a junior researcher here at the Asser Institute. And it's my pleasure to welcome you here tonight for this event. The event is called Hate Speech and Incitement, International Criminal and Humanitarian Law Perspectives. So tonight's lecture is part of the HILAC Lecture series, which stands for the Hague Initiative for Law and Armed Conflicts. The HILAC series has been organized since 2005 by the Asser Institute in cooperation with the Netherlands Red Cross and the Amsterdam Center for International Law. This event also takes place within the context of the IHCL Platform, which is a network of Netherlands and Belgium-based academics in the fields of IHL and ICL. The IHCL Platform was established in 2010 and is also coordinated by the Asser Institute. I would like to thank the Transboundary Legal Studies Department of the Faculty of Law of the University of Groningen for their generous support for this event. So tonight's HILAC lecture will be provided by Audrey Fino, followed by the responses of our three discussants also sitting here. Afterwards, we will move to an open Q&A. And for those online, please enter any questions you have in the chat during the lecture. I should mention that this event is being recorded and will be put on our YouTube channel in the coming weeks. So I would now like to briefly introduce our speakers, and I will begin with Audrey Fino, who is a lecturer of international humanitarian and human rights law and a PhD researcher at the University of Groningen. She formerly worked at the Extraordinary Chambers of the Courts of Cambodia, the International Criminal Tribunal for the former Yugoslavia, and at the UN Office of the High Commissioner for Human Rights. Audrey's publications include Defining Hate Speech, a seemingly elusive task, and a critique of the UN strategy and guidance on hate speech, some legal considerations. We also have Dr. Uladzislau Belavusau, who is a senior researcher in European law here at the T.M.C. Asser Institute. His research and teaching covers various areas of EU, especially constitutional and anti-discrimination law, human rights, and memory politics. He is the head of the Dutch team in the International Research Consortium for a study of memory laws and policies, which is called Democracy, and that's sponsored by the Volkswagen Foundation. We also have Predrag Dojčinović, who is adjunct professor and research affiliate at the Gladstein Family Human Rights Institute at the University of Connecticut. From 1998 to 2017, he worked for the Office of the Prosecutor at the ICTY, and he is the author and editor of Propaganda, War Crimes, Trials, and International Law, From Speaker's Corner to War Crimes, and Propaganda and International Criminal Law, From Cognition to Criminality. Finally, we have Judge Alphons Orie, who was from 1971 to 1980 a lecturer at Leiden University at the Department of Criminal Law. In 1980, he was admitted to the bar of the Supreme Court of the Netherlands. He was appointed Justice of the Supreme Court of the Netherlands in 1997. He was also elected as a judge of the ICTY in 2001, where he served until 2017. Since 2011, he is judge on the roster of the United Nations International Residual Mechanism for Criminal Tribunals. So Audrey, I would like to pass the floor on to you for the lecture. Thank you very much.
Thank you, James. Good evening. My lecture today draws from research that I've been carrying out on hate speech and incitement in public international law, and primarily in international human rights law, international criminal law, and international humanitarian law. These three fields of law are related but distinct. And I have looked at hate speech and incitement in each of these fields. What I wish to discuss today is answers to the questions that you see on your screen, and namely, What are hate speech and incitement? How do we distinguish between them? What kind of a speech act does international humanitarian law prescribe? And I should add that today's focus, the focus of this lecture is actually on humanitarian law, also known as the law of armed conflict or the law of war, basically the law that covers behavior in times of armed conflict, whether international or non-international, but also in times of occupation. I will also look with regard to international humanitarian law, how international criminal law, what I call ICL, and international human rights law, IHRL, can help us or inform us in its understanding. Finally, I will, zooming out into my general research, I will share with you some general observations that I found studying these various fields of law, and I will ask many questions. Since these are preliminary conclusions, I invite all of you, the panelists, and also you in the audience, to please intervene, ask questions, and pinpoint to me if I have overlooked or downplayed any aspect that you may find important. Yes. So, Secretary General Antonio Guterres of the United Nations has said that over the past 75 years, hate speech has been a precursor to atrocity crimes. The UN has actually called hate speech a menace to democratic values, peace, and societal stability. Indeed, the UN Office of Genocide Prevention has actually considered hate speech to be an indicator of heightened tensions within any society, and also it calls it an early warning sign of mass violations of human rights, of crimes against humanity, war crimes, and even genocide. This harm in hate speech is also the reason why many states legislate against some forms of hate speech. The International Committee of the Red Cross, the ICRC, actually now acknowledges that one of its main challenges in the field is the increase and spread of disinformation, misinformation, propaganda, and hate speech, and their effect offline. Unfortunately, it persists in the current world and in the world that we live in. And the concern of the international community has been highlighted by the very recent ICJ institution started by South Africa against Israel for what is happening in Gaza, but also I have to mention the Gambia and versus Myanmar, where we also see incitement and its prohibition playing a key role in those proceedings. So what is hate speech? Do we know it when we see it? I don't think so. As there is still no one universal definition of hate speech, I have tried through my research to come up with an integrated definition that could possibly be used across all the three fields that I've mentioned. And what you see here is what I will be using as a working definition today. So basically, I call incitement any intentionally urging another person to take immediate criminal action. On the other hand, in hate speech, I narrowly define as all types of expression knows its expression. So it's not just speech, but it can also be artistic expression other than incitement. So anything else but incitement would be hate speech that attacks, threatens, or uses pejorative or discriminatory language. But targeting a person or a group of people based on an identity factor. And I'll give some examples of identity factors there. These could be nationality, someone's ethnicity, someone's religion, or even someone's sexual orientation. But once we have an integrated definition, the story does not end there, does it? We need to distinguish between these two forms of speech acts, incitement and hate speech. So how do we distinguish between them? I have looked at the practice of international criminal law and human rights law and tried to synthesize what is the common denominator between these two fields of law. And I come up with these 6 factors. The first one is the content of the speech. Obviously, you would say, we'd look at the words, but not just the words, in the language, how it's spoken and what is intended, and importantly, how the audience understands that language. We look at the context of the speech. So was the speech given in the context of a run-up to a political election? Was the speech given in situations of heightened strife or violence on the streets? Was the speech given in a position in situations of war? Those are the contextual factors that judgments and decisions of treaty bodies have looked at. Of course, the status of the speaker. By this, we mean the position of the speaker in the society. Is the speaker someone who has charisma, is authoritative? And in this context, I always recall the Sexton appeals chamber decision, or judgment, which actually mentioned that Sexton, by the way, in brackets, Sexton was a Serb political leader in the early 1990s, who was prosecuted and ultimately convicted for incitement as persecution. And the appeals chamber actually noted that Sexton was regarded as a god by his followers. That is the kind of authority he had on the audience, on his audience, which means that, of course, if he incited to commit a crime, the likelihood is that they would have believed him and may have done it. That is the idea of looking at these factors to see the degree of connection there could also be, or influence that the speaker, the words have on the actual acts that follow. Of course, the intent of the speaker is also important. So if I were to be reading out or quoting what some anti-Semitist message in the context of what happened in the international military tribunals after the Second World War now, could I be charged with incitement to hate speech? No. Because not only because we're in a democracy, but also because it was for an educational purpose. This is an educational reason, so that my intent was not criminal, to incite someone to commit a crime. There are other important factors to consider. One note before I move on, because of timing issues, the likelihood that violence will follow. This is important, especially for criminal law purposes, when the incitement is not an inchoate crime. Inchoate crime means that the actual fact that you incite is criminal in and of itself. So you don't have to actually have ensuing acts of violence, for example, after it. Which leads me to some popular speech acts, but I want to pinpoint first to the third column here on the screen, which is from the Genocide Convention. And I mention here direct and public incitement to commit genocide is one of the few that I have found forms of hate speech, or I actually correcting myself, forms of incitement that is an inchoate crime. So the actual fact that one finds, and note, it's not incitement to genocide, as we have seen in some of the media reports of the ICJ case recently. It is direct and public incitement to genocide. That is a crime, and that by itself, therefore, no genocide need be committed, it's criminal. Yeah, so that is important to keep in mind. In this here, I tried to, with color, tried to indicate the similarities between the other two treaties, which are human rights treaty, the first one being the International Covenant of Civil and Political Rights. The second one is the International Convention for the Elimination of Racial Discrimination. The similarities and differences in the actual wordings or speech acts, as I call them, and what is required. Note that all three conventions are mandatory for states to legislate against them, so they have to. The difference between them is that the human rights treaties do not explain how it was. So do we penalize it, that is, use the criminal law as a sanction? Do we use civil law, we give a fine? Or do we use administrative law? So that's the current way that we interpret sanctions in human rights law. Of course, the Genocide Convention is a criminal law convention, so that actually requires a penal sanction. But there are more, and that's very hard for you to read, so I'm not going to focus so much on that. But there are more speech acts that I found, and the orange one is human rights law, the middle one is international criminal law, persecution as a crime against humanity, I've already mentioned it, hate speech and calls to violence and calls to commit crimes can, in and of themselves, by themselves, constitute persecution as a crime against humanity. And lastly, war crimes. And this is the field that I'm going to be focusing on, because war crimes, in other words, covers the criminal repressive regime under the 4 Geneva Conventions and additional protocols that govern, that are the center or the core of international human rights law. Those also provide certain forms of hate speech that should be criminalized in this case. And the most obvious one is ordering. So a military commander cannot order that his followers, his subordinates, commit war crimes or other violations of international humanitarian law. Here is where I go a bit deeper into international humanitarian law and use this as an example of how the various fields of law that I've been looking at can actually inform our knowledge of it. So delving deeper into the 4 Geneva Conventions and the additional protocols, I noted that there is no reference to hate speech or incitement as such within the 4 corners of that law. But I identified a number of speech acts which are on your left on the screen there, which are on your left, which are actually what I would call forms of speech acts. And these are threats of violence, for example, threats of murder. I threaten someone with torture. That is a form of course, when it's verbal, but even when it's written, it's a threat. It's a form of hate speech. Threats of outrages upon personal dignity. Note the old-fashioned words, but actually what it means is it's a challenge to, a threat to humiliating, degrading, possibly insulting words that can be made by people. Insults, intimidation are also forms of speech acts that are prohibited in various provisions of the Geneva Conventions. I know that in my little notes there, I'm referring to Geneva Convention 4, which is the convention that covers civilians in times of war. Similar prohibitions appear also in Geneva Convention 3, governing prisoners of war, and also to a more limited extent in the additional protocol 2, which covers non-international armed conflict. Most of the Geneva Conventions, except for common Article 3, govern international armed conflicts. So I think I should say what grave breaches, at least as I'm using it, are. Grave breaches are the most serious violations of these 4 Geneva Conventions and Addition Protocol. They require a criminal sanction and have also the possibility of universal jurisdiction kicking in. Which doesn't mean that other breaches of the Geneva Conventions are not criminal, but some of them are not. So we have to distinguish. My research is still ongoing here. Up to now, I can say that from the practice of the International Criminal Tribunals, which is, of course, relevant because International Criminal Tribunals, actually, their jurisdiction covers also war crimes. So these Geneva Conventions is something that we have quite some jurisprudence on from those tribunals. And of course, the ICC at the moment, that is most relevant jurisprudence. They have actually not clearly distinguished between grave breaches and other non-grave breaches, unless, of course, the grave breach is listed as such in the provision that covers grave breaches. So let me clarify this better. What we see is that the Geneva Conventions show us what the grave breaches are. They're listed in a certain provision of the law. The speech acts that I list on the left are not listed there. But we shouldn't think that they are not criminal. They may be. And what I have seen in the jurisprudence is that many times they either, and that's the first bullet point here on the right, is they're often considered, hate speech is often, so in this case, threats or intimidation or insult, are considered as a factual evidence or an additional factor to go and prove one of the listed grave breaches. So it's used cumulatively. And I can give an example. For example, torture. Torture is a listed grave breach. The threat of torture and then subsequent torture in the form of sexual violence, for example, has been found to actually constitute the crime of torture. How do they do this? Many times, when the law is silent, especially in international humanitarian law, where international customary law is also a source, and for those international lawyers in the room, public international lawyers, one of the sources is not only treaty law, but customary law. So I'm going round in circle. What I want to say is that many times humanitarian law reverts to customary international law. So what jurisprudence has done is it has also, if it's not written in the black letter law, as we call it, right? They look at customary law. And they have actually found that, for example, threats of terror can amount and have amounted to the crime of terrorization of civilians. The same with threats of rape and threats of sexual violence in the IHCL practice have been considered to constitute the crime of rape and the crime of sexual violence, but only when rape and sexual violence have also been committed. So in a way, it's kind of contextual. It's not completely clear if just a threat of violence or a threat of rape would amount to a grave breach. I suspect it would not. Another way, and this I mentioned, for example, the ICTY judgment of Furunzia, which actually it's known that it kind of identified that rape was such an important grave breach, but also that the threat, the actual verbal threat, was also important to acknowledge. Another thing which my research has not yet shown, but I hope it will show, so is that human rights law actually applies concurrently to international humanitarian law when there is an armed conflict. And I want to say this, even knowing that lately the last 2 or 3 years, the European Court of Justice said something completely different. But I have to be, it is very relevant now to know that basically the mainstream view in international law is that in times of armed conflict, the international humanitarian law applies side by side with human rights law. So what I am proposing is that we also look at human rights law, what human rights law has to say on threats, for example, on insults, but also on other forms of hate speech that is not addressed explicitly in the treaties, to see if it can complement our legal picture to ensure that serious violations of threats of IHL, such as the ones listed on the left, will actually be criminalized. Lastly, relatedly, but not completely linked to it, is something that I'd like you all to keep in mind, that propaganda as such is permitted under international humanitarian law. Propaganda and misinformation. And in the old terms of the Geneva Conventions, they're called ruses of war, tricks of war. Unless the practice now says that, unless those ruses of war, that propaganda amounts to incitement. And the practice that I found is by the International Committee of the Red Cross in their customary law research database that they update regularly. That is the analysis of, briefly and a very high level, of what IHL, how we can use international humanitarian law and be informed by other systems of law and therefore come up with a holistic approach to countering hate speech and incitement in times of armed conflict. So if we zoom out again, and I will here be referring more to my general research, not just IHL, I want to propose a couple of preliminary conclusions that I have come up with, and also pose some questions to you for the panelists for further discussion, possibly later on, and for you in the audience. The first thing is, I think it's pretty clear, the law is fragmented. Sometimes the law is also not complete. There are gaps in the law. But its practice, especially that of human rights law and international criminal law, is instructive. Of course, the international criminal lawyers in the room will be jumping up and down on their seats and saying, hey, how can we just import human rights law into the rigors of international criminal law? We are bound by the principle of legality, which precludes any progressive development of the law. True. But the principle of legality, which by the way means that no one can be accused and convicted of a crime if the conduct encapsulated in that crime was not a crime at the time that conduct took place. So basically, it has to be a crime. The hate speech or the incitement has to be a crime at the time the person spoke that words before he or she can be convicted. That's the principle of legality, which, by the way, is also a human rights principle. But while lately we've seen, especially from the International Criminal Court, very much a tendency to adopt restrictive interpretations of the law, there is something to be said about a couple of ICTY appeals chambers decision, such as the Alexovsky and the Milutinović decision, which, by the way, has also been adopted by the ICC recently, that the principle of legality does actually not preclude progressive development of the law if the essence of the crime is not affected. Of course, this will lead all of us to say, but what is the essence of the crime? And for that, I think we need another PhD and another lecture. But you see, I want to highlight the fact that it's not just a closed door, the principle of legality. We have to be brave enough to engage with that. Before I stop, a couple of other questions. I think I'll start with the last one first. So why am I saying all this? Because can we work with what we have, with the law as it is, by applying the rules of interpretation of international law to help us address and counter hate speech and incitement, even if sometimes the law is not as strong as we want it to be? Other scholars have noted that the law is insufficient, and especially in international humanitarian law, that we need a new unified treaty that covers atrocity speech crimes. And one big proponent of this in this field is Professor Gregory Gordon, who proposes this. Others have also said that we may need some amendments or a new additional protocol to these treaties. This is also proposed by a number of scholars who have drawn up the Heartland Guidelines on Speech Crimes. You may probably not be surprised that I'm tending towards the last one, which is let's use what we have. Let's learn what other systems of law have done in the field whether it's humanitarian law or criminal law or international human rights law, and make the best of what we have within the legal constraints. But let's not be afraid of interpretation, and especially teleological interpretation, purposive interpretation, if it could help stop the tide of this menace of hate speech and incitement. That is all from me for the moment. Thank you for your attention.
Right, I guess the floor is mine. Audrey, thank you so much for this lecture. I should immediately say that I feel like an imposter, an intruder in this audience, because if the lecture is essentially about international criminal law, international humanitarian law, despite my affiliation with this wonderful institute, I'm neither of that. I'm a scholar of, if anything, comparative constitutional law and the law of the European Union. So my perspective, unsurprisingly, will touch with my comfort zone, but it will try to interact a little bit with the points raised by Audrey. And if anything, that was a learning exercise for me, as mentioned. And in this learning exercise, I hope to find answers whether actually constitutional lawyers are muddling waters too much and international lawyers have a much clearer perspective. And unfortunately, this is something that I didn't find. So I see that the international lawyers are struggling with pretty much the same problems as we do in national criminal law or in comparative constitutional law, namely the definitional problems. Yeah, this equilibrism, this elusive task of defining hate speech, as Audrey also refers to in her publications, very much present in the literature on comparative constitutional, comparative criminal law. I call these the binary paradoxes. So within the next 7 minutes or so, I'll try to address at least a couple of those binaries that might be helpful also for the discussion on international criminal law and humanitarian law, especially as Audrey underlined, lots of the discussion tends to migrate from either national or international discourse on comparative human rights. So the first elusive problem of these dualities comes with, of course, what we put into that box. Historically, hate speech as the discussion emerged even a little bit earlier than the term in the 80s. So I won't bore you with all the difficulties of reconstructing this discourse, but the discourse is very, very American, surprisingly for the country that is known to be as the bastion on the level of the Supreme Court of non-intrusive regulation of hate speech, so to say. But the discussion gets us into the 20s, and we get into the familiar discussion about the Jews, unsurprisingly, the Irish and the blacks, of course, the Afro-Americans, and mostly it addressed the advertisement back then and the 7 states attempting to regulate that issue. Back then, it didn't have much of a problematic resistance, let's say, on the federal level, something that we observed in the discussion of the Supreme Court later in the 70s, 80s, 90s, that leads to this famous paradox, like the US libertarian approach on hate speech and supposedly very restrictive, very regulatory European continental approach. But that discussion is important because in combination with what was going on in the Third Republic in France and Weimar Republic in Germany, the story we all know, basically the hardcore anti-Semitism and very unregulated speech back then, leading probably, as insinuated, to the election to come into force of the Nazis in the Weimar Republic in a pretty democratic way. Pretty much that discussion is at the core of the whole conceptualization of hate speech. And this conceptualization is not without ironies, because the term is coming from the country that supposedly had the most libertarian interpretation amongst liberal democracies back then in the 60s, 70s, throughout 90s, and actually I would even argue to a certain degree until now the level of the US Supreme Court. So it's rather the academic terminology that paved the way for hate speech as such, because the same phenomenon in the context of the rising streitbare Demokratie, the militant democracy, the idea that because Hitler came to power abusing hate speech, so to say, in the Weimar Republic, there should be some repercussions, some limitations for democracy itself, for the regulations of human rights, including the core human rights such as freedom of religion, freedom of expression, freedom of association. At the end of the day, they are not like torture or life. Right to life, they are not limitless. So we need to put some limits and put some regulations. And it leads to a famous sample in the of Volksverhetzung. Again, the German criminal law is extremely important there because it was mimicked in many diverse ways throughout continental Europe and even exported beyond the idea that hate speech should be excluded, the incitement to hatred should be excluded from regulation. But again, nobody used hate speech. I would tell more, nobody ever mentioned hate speech as the concept at the level of the European Court of Human Rights up until somewhere 2016, 17, when it was actively promoted on the apparatus of the European Court of Human Rights, doing all sorts of, just the famous guidance of the European Supreme Court, those summaries, how to deal with certain issues, with abortion, with freedom of religion, with blasphemy, and then all of a sudden we have hate speech. And in the recent case law, especially in the dissenting opinion, more and more often we face this hate speech regulation. Moreover, at the level of the European Union, hate speech as the terminology is again emerging essentially rather as a slang, migrating from academic discourse, and then being more and more convenient terms. And recently I see it more and more in the documents. But the major document, if we have anything at the level of the European Union about hate speech, is the, of course, Council regulation on the xenophobic expression. Again, you would hardly even see hate speech as the term there. Why I'm saying this is because of the duality. So you see, there are lots of ironies in this whole term of hate speech coming from the country that has supposedly a very libertarian interpretation of hate speech in the first place. Definitely nothing to do with our familiar patterns of militant democracy in Europe. Having said that, it would be a terrible folklorization of American law and comparative law in general to reproduce those two models as extremely antagonistic, because actually the United States have a lot of regulation of hate speech. It's actually a way more on the level of the labor law through the so-called mechanism of harassment, the famous part. Title, I'm sorry, I always call it Act. It's Title 7 of the Civil Rights Act, of course, of 1964. And the idea that a lot of what we catch through criminal law, in Europe, as we are very comfortable with this model, spread from French and German traditions all over the continent, is caught in the American settings and as the hostile working environment. And it is a way more regulated than it is in Europe whenever we analyze the patterns of that regulation. So we are facing another binary. If international lawyers are facing the binary of hate speech per se, some sort of discriminatory speech and then incitement to hatred as different categories, and many others that Audrey wonderfully exposes in her publications, then constitutional and criminal lawyers are foremost facing the definitional problem on what is incitement on the continental level. But then with this incitement, I mean, there are hilarious jurisprudences, like, for example, Hungarian Constitutional Court that for almost 15 years tried to define incitement, because there was various attempts of the Hungarian parliament to extend incitement to, let's say, arousal of hatred, or the exaggerated racist expressions, or totalitarian symbols as put not as a separate category, but in terms of the incitement. And to all of that, the Supreme Court of Hungary was saying, cuckoo, we don't know what's that, we know what is incitement. So apparently everybody's comfortable in Europe with this incitement approach. But then spreading this box is problematic. But then there is another dichotomy. So far, when talking about hate speech, we mostly addressed, of course, hate speech as racist or xenophobic hate speech, right? But then we see, at least on the European level, the European Court of Human Rights and the Council of Europe in general is reproducing mimicking this pattern for other social groups. Of course, the biggest, the women, yeah, this sexist hate speech, then the homophobic hate speech since the last 5-6 years, also as we know from the jurisprudence of the European Court of Human Rights, perhaps transphobic speech as far as the sexual identity is concerned. Perhaps at a certain age, at least at the national jurisprudences, we see the ageist hate speech entering the market, so to say. So this market of hate speech nomenclature is in itself spreading and multiplying every year, and of course that also leads to separate discussions on whether it's actually even limitless in terms of defining social groups. Then another problem is, as I've mentioned, how much of what we regulate as hate speech on the level of the criminal law in other jurisdictions is actually pictured as the part of the labor law story. I mean, the US is not the only country with this libertarian approach. One of the biggest liberal democracies in terms of population, of course, Japan, barely has any hate speech regulation, which doesn't say that there is no some sort of hostile working environment or harassment regulation on the level of the labor law. So it's also absolutely not true to say that if we don't have criminal legislation against hate speech, we are at risk of creating and setting up a society that is extremely racist. Obviously, Japanese society, as any free market of ideas, is not unproblematic on many accounts, including Japanese military history and other problematic aspects. But we cannot really accuse Japan as some, I don't know, bastion or champion of racism in East Asia. And again, I'm saying it with all criticism and respect for the counter arguments. But it would be perhaps also completely naive to assume that the way of regulating hate speech so aggressively as we do in Europe under this Milton democracy framework is the only way to preserve democracy as such. Another thing is that it's spreading also in terms of the package on what is incitement in itself. And a big part of my own research deals with politics of memory. And of course, in that context, I research genocide denialism, or rather the responses, legal responses in diverse jurisdictions to genocide denialism generally, be it Holocaust denialism, Armenian genocide denialism, Tutsi genocide, etc. Or broadly what the French claimed once to be les lois mémorielles, so the diverse way we deal with problematic past, more increasingly with criminal measures. And again, we see the same muddling waters as we see with incitement and hatred, because some jurisdictions put it as the part of incitement to hatred to broadly hate speech. It's also the problem broadly of international law from the cases like Forisson, of course, and the case law of the European Human Rights Committee, and then the same discussion is present, of course, on the level of the comparative law, how to deal with those. Are those categories, hate speech and genocide denialism, are distinguishable? On the level of the EU, two categories are somehow put, for example, in the aforementioned document of the Council decision on xenophobic speech. And genocide denialism is also mentioned there in very broad terms, not as Holocaust denialism, but as addressed by the Rome Statute, as the Rome Statute addresses the samples of genocide. But then there is also this fashion to think about Europe, of course, as this civilisatrice, as this la mission civilisatrice, this sample of perhaps very positive examples of regulation. So if Europe does something, perhaps it has to be replicated. And then also the tendency to mask the violations, explicit violations of human rights and actually the oppressive regimes and authoritarian ways of dealing with freedom of expression under the mantle of hate speech. And that's the biggest problem and dichotomy with hate speech. Just to give one example, and perhaps with this I will be finishing my narration. What happened this Sunday in Turkey? An Israeli footballer, Sagif Yekezel, holds up the bandage famously, yeah, where he shows the bandage says 100 days, 7th of October, and the Star of David, referring, of course, to the 100 days that have passed since the sad tragic events in Israel on the 7th of October. Immediately, the Minister of Justice starts the case against the footballer, under which allegation? Well, Turkey is usually known in that context for the so-called denigration of Turkishness, Article 301. In that case, it's 312, the convenient zone of hate speech. And again, replicating a very much European discourse on hate speech as not meeting the standards and the context and the cultural sensitivities of the Turkish society that chose a certain, perhaps one-sided view on the events in Gaza and Israel. So to which degree this case of the footballer who managed to escape Turkey, excuse me, but that doesn't mean that the case against him is over in Turkey itself, deals with hate speech, is of course a big question. But Turkey is one of those many authoritarian or quasi-authoritarian countries, societies broadly, that are using this replicated model of militant democracy to safeguard quite a bunch of injustices, I should admit, and rather oppressive, violent, anti-dissident measures in their countries. And of course, this is something that we should be absolutely prudent in, and we are constantly aware about this in comparative constitutional or criminal law. This is the kind of central leitmotif of the discussion, whether we need hate speech legislation in the first place. And I'm also curious to what degree that's also the matter of the paradigm of the discussion, international criminal and humanitarian law. But this is also the cornerstone of the discussion. And if I'm allowed to add just one question to that, something that was of huge curiosity for me. One distinction that we always hold in criminal law when dealing with hate speech is the distinction between hate speech per se and hate crime. By hate crime, we mean, of course, things like murder, rape, or any other crime with aggravated circumstances, right? So when we are referring to the Geneva Convention in the sense that you were referring to torture, rape, for example, is there something similar of this distinction emerging between incitement to hatred, hate speech per se, as something that I assume is more like the academic discussion then, and this hate crime, again, is it formulated in maybe in different categories? So does it have some symmetry with what we are doing in comparative criminal and constitutional law? At this point, I'll limit my freedom of expression. Thank you very much.
Thank you very much. As I have been I have been asked or tasked by Audrey to address the concept of propaganda that I have been researching and applying in legal practice for, I think, well over 25 years now. I spent some time thinking today, how long have I actually been in this field? I will start first of all by saying that if we look at the title of our panel discussion today, that hate speech and incitement have always been part of that container concept called propaganda. And I think that comes naturally to all of us as a piece of knowledge that we pick up from our societies, even private lives sometimes. So what is very important, and Audrey may have mentioned it already in the beginning, is what propaganda is, or what propaganda as a concept is not. So let me first start by saying what propaganda is not. Well, as Judge Lattanzi clearly stated in her dissenting opinion in the appeal judgment of the Sexton case that Audrey mentioned, propaganda, and I'm quoting Judge Lattanzi, propaganda, the use of propaganda is not in itself a criminal act, comma, but, and I like this conjunction very much in law because you see that there is a lot more to be said after that. Every time someone mentions Sexton case, I spent many years working on that case, and I had the privilege of actually finding this piece of evidence that got him convicted. That was that speech that was delivered by him on the 6th of May, 1992, that he so courageously published in two of his books as a transcripts of the speech. But what's interesting about that speech that he delivered was indeed what Audrey already mentioned, was that he was, as a matter of fact, convicted for, one can say, a single speech act. And that speech act was a derogatory term used by Serbs to refer to the Croats, in this case, the Croatian Catholic population of the small village where he delivered his speech. The word is Ustaše. It is a reference to the Nazi, Croatian Nazi allies from the Second World War. So that was a single speech act that can actually fall under the ambit of direct hate speech. Direct in terms of understanding of that speech act by the audience that was present there, and that goes to the contextual circumstances of the speech that was delivered on that occasion. And then again, as Audrey very well pointed out, it was very important who Sexton was. He was a leader of one of the most powerful political parties at this moment. He was not only a political leader, but a military leader of a paramilitary formation that was incorporated in that political party, the Serbian Radical Party. And indeed, that reference to him as being perceived as God comes from one of our witnesses. He called on the stand to testify about that. And so all of these elements are definitely very important for the incorporation of hate speech into the concept of propaganda in general. But then again, let me go back to this conjunction "but" from Judge Lattanzi's statement. Well, in legal theory, we make a distinction between two generic forms of propaganda. One is war propaganda, and the other one is propaganda for war. They're two not necessarily related types of propaganda. So I believe that this distinction may have been made by one of your old lecturers, maybe from 15 or 20 years ago here, and my colleague Michael Koenig, who published an excellent book, The Prohibition of Propaganda for War in International Law. And I think this is where this distinction may have been made for the first time. So what is war propaganda? Well, war propaganda is a type of propaganda that may contribute and has in fact been contributed for decades to the commission of three core international crimes: war crimes, crimes against humanity, and genocide. So the atrocity crimes, as they're also known, including the conduct called ethnic cleansing. So hate speech, in other words, again, if I can re-emphasize, that has always been an integral part of that process. I think the existing jurisprudence that we have and historical trial records are really more than clear on that issue. But what's far more interesting for me here today is, in fact, that generic type of propaganda called propaganda for war. Now, that propaganda has, in a nutshell, been defined as a form of incitement to a war of aggression. So, and possibly, of course, as a result of specific acts that we know what they are, the crime of aggression, ultimately. So if we look at this working definition, we see that there are three components. We are looking at a sort of loose legal equation, if you like, or a micro legal theory with propaganda for war, incitement, and war of aggression. So how do we put these three together? Well, essentially, they've been generated and derived from Article 20 of the ICCPR, and I believe you mentioned this treaty. So let me just, I wrote down the first two paragraphs from the treaty for the sake of clarification. Any propaganda for war shall be prohibited by law. 1. 2. Any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. So we see that these three components that I mentioned, propaganda for war, hate speech, and incitement, meet together or have been generated, in fact, or derived from this treaty. And that is an important fact for any lawyer as a working point, I guess, or a point of departure. On hate speech in this context, I wouldn't want to add much more, because some of the most important things have already been said, except that I would like to emphasize again, indeed, this that in most policy and academic papers, including jurisprudence, there is this sort of mantra that we are running into every time, saying that there is no universally accepted definition of the expression hate speech. And I guess thanks to this fact, there is an emerging field of study that has been trying for years, if not decades, to define or redefine the nature and position status of hate speech within international criminal law in the first place. Well, this is what propaganda as a single concept and hate speech share. As a matter of fact, they're neither a substantive crime nor a mode of liability. So what are they as a matter of fact? If we cannot charge directly hate speech and we cannot charge propaganda, we have to find a way around to place them within a slightly different legal concept within other crimes or modes of liability. So what we know about hate speech, if you do a thorough research through the existing jurisprudences, are actually two things. And I will quote them verbatim from the Nahimana and others' judgment, one of the most famous propaganda cases to this day, I believe, tried by the ICTR, as you probably all know, that says this much about hate speech. It is an act of discrimination and an underlying act of persecution. So these are the most solid facts that we have from jurisprudence. So can we build a definition on that? I'm not sure. I don't know. So in some way, the role of hate speech has sort of been downplayed. We know it's very important. We know it plays an important role, but it has always stayed outside the ambit of substantive crimes and modes of liability. It is an important element, definitely. About the incitement, I would like to bring one or two just brief clarifications that have been bothering me as an issue. If we read jurisprudence carefully, we will run into one and the same problem, recurring problem from judgment to judgment. Incitement has lexical synonyms. It has a broad range of synonyms. One of them is instigation. I have been constantly running into this confusing conjunction of these two elements, these two concepts that are in fact in law completely different. In language, they may be the same and synonymous, but in law, of course, they are different. Incitement is a substantive crime, whereas instigation or solicitation now is a mode of liability. So that is very important to keep in mind for lawyers or legal researchers here. And there are many other differences, obviously, such as key differences. Instigation has the requirement of the proof of causal nexus, whereas incitement does not. So these are some nitty-gritty differences that are very important for the determination whether something is incitement or instigation. In the case of Vojislav Šešelj, we actually charged him with instigation, so he was ultimately convicted for the crime of persecution. Persecution is a crime against humanity. So, but let me go back again and ask the question that I have been meaning to ask here, to go back to my point of departure about propaganda for war as a form of incitement to a war of aggression and possibly the crime of aggression. So if we look at Article 8 bis, of course, of the Rome Statute that provides, I think, fairly clear provisions for the crime of aggression, we see several key concepts. It includes planning, preparation, initiation, or, there we go with the conjunction here, or execution, and so on and so forth. So this conjunction or, in fact, makes a difference, a distinction. It builds a wall between this crime as an inchoate crime, and I'm glad that you mentioned it in your lecture, and the complete crime. The crime that may have been completed or will be completed in some situation. As a matter of fact, this is not my idea. Judge Cassese came up with that several decades ago in his textbook on international criminal law, when he tried to make an assessment of the meaning of this key concept of planning, preparation, initiation, and the crime of conspiracy as well. So what's important here is also to keep in mind the inchoate nature of this constellation of concepts: propaganda for war from the ICCPR, and hate speech and incitement, of course, that may lead to a war of aggression. So why am I saying this? Because it has a strong support in the jurisprudence starting from the Nuremberg trial onwards. Where does this support come from? Where do the factual circumstances come from? So for the students of history of international criminal law, you will probably remember, if you've read and reread the judgment, it's not that long, from Nuremberg, you will remember that there are at least two, contextually speaking, two major narratives that run parallelly and converge at certain point. One is the idea of the Nazi leaders who were on trial, including Hitler, who wasn't, to create an entity called or imagined as a greater Germany. Now, that is a very important evidentiary component of that trial. Parallel to that, we have hate speech, and I'm not going to go and cite all of the exhibits that were introduced in the course of the trial in order to demonize the population of the territories that were supposed to be colonized, conquered, and ultimately annexed to that imagined entity called Greater Germany. So that was, of course, all placed within the context of the crimes against peace at the time. Now that would be the crime of aggression, right? What's interesting here is that we have two identical narratives at the ICTY, and I believe that Judge Orie would remember some of these arguments in some of the trials where when we tried political leaders. So we have the concepts of Greater Serbia and to a lesser extent Greater Croatia. They provided us this contextual evidence for these trials in terms of common purpose, common goals, and so on and so forth. The legal framework was a mode of liability called joint criminal enterprise. Now it's something else at the ICC. And again, hate speech ran parallelly to that. The political leaders, on the Serbian and Croatian side, had to demonize and discriminate against the population of the territories they were going to conquer and annex within this political idea and project. So now we have something very similar in the Ukrainian situation, and this is my final point. We have the idea of Greater Russia. That has been out there for over 20 years. I have been following this very carefully. Putin has published and publicly spoken about creating a Greater Russia in many different ways. It's all public, open sources, so there is no intercepted telephone conversations or secret documents or anything like that. At the same time, this narrative put forward by him and his propagandists is accompanied by very strong components of hate speech. I'm sure all of you know that they usually refer not necessarily only to the combatants in Ukraine, but to the entire population and as Nazis, and that they want to denazify Ukraine and so on and so forth. So again, we have these two major narratives. So the question here from me to you as a brilliant legal minds, of course, would be, could these colonial and imperial ideas, could they be that lead or may lead to wars of aggression? And we have this idea recently of creating a Greater Russia, and through the violent annexation of the Crimea in 2014, and then we have the annexation of 4 other regions, Luhansk, Donetsk, Zaporizhia, and Kherson in 2022. So could such acts be actually prosecuted as propaganda for war? That is the second generic type of propaganda, both as an inchoate crime and as a completed crime, as it has been done with direct and public incitement to commit genocide at the ICTR, by the way. So that was my question too. Thank you.
I'm next. Then I look at the clock. I see that I've got minus 10 minutes left to tell you what I wanted to tell you. I'll try to do my best.
We started late, so feel free to go a bit longer.
I am not a hate speech expert in no way. I never dealt with any such case apart from having been involved in the initial stages of the Sexton case, though it was too short to dive into the into many of the legal substance of that case. Hate speech for me is a puzzling concept, or is it a concept, or should we call it a phenomenon? I don't know. It certainly is not primarily a legal concept, but hate speech can be both forbidden or just undesirable and perhaps of great concern to society. But also in this respect, as in so many others, the legal situation is pretty unclear. You could ask yourself, why is denial of historical facts, according to the Committee on Civil and Political Rights, not something you could forbid? And why does the European Court of Human Rights say that Holocaust denial, that may be an offense? And isn't it true that the harm done by, if I could say, the bottom level of hate speech, the ones which are not forbidden, can cause huge damage, which would in itself justify to make it an offense? Ask myself, is it a concept or not? I do know that hate speech pops up at every corner and it's there again and again, but whether it's a factual thing, it's speech, although it could be writing as well, but it's speech, so it's an expression of thoughts. And you'll not be surprised that an expression of thoughts will be everywhere when we are talking about both criminal law, but also in normal life. So hate speech, when will speech become hate speech? I don't know. Of course, from my point of view, I'm rather struggling with the ways in which hate speech find its way in criminal law and procedure. And of course, we're focusing very much on international criminal law and procedure, but of course, it happens in domestic law as well. We have in the Netherlands a rather well-known case against someone who's now involved in the forming of a new government, Mr. Wilders. He was not prosecuted for hate speech, but to say in a public meeting aloud, do we want more or less Moroccans in the Netherlands, is of course comes close to what we hate speech, but hate speech in itself is not as such a crime in the Netherlands. If there are reasons to prosecute on the basis of hate speech, that means someone is supposed to have delivered a speech which some people say is a hate speech. I can't make more out of it. Then several options may be open. Is there and all these options have their own questions. Is there a sufficient basis to prosecute when hate speech just incites to violence or to crime, but if such violence does not ensue? That's still a question which is not clearly answered. Under what circumstances can hate speech in itself already constitute persecution as a crime against humanity? And what is required for hate speech to become a mode of liability? Instigating, you mentioned it several times, aiding and abetting, you could even think of ordering, you could think of. So there, I would say, in almost every respect, hate speech finds an option to in its way to the court. You see that clearly and it has been mentioned also briefly before, that in the Sexton case, the appeals chamber considered, I'm not talking about the trial chamber judgment. It's a judgment of 100 pages, and there is a concurring opinion for this acquittal of 500 pages. So that's really too much for me to fully understand. But in the sexual case, hate speech was part of two elements, two counts in the indictment. The one was that Mr. Sessions' speech incited violence that denigrated and violated the right to security of members of the Croatian population of Herzegovina, thereby committing the crime of persecution based on a violation of the right to security as a crime against humanity. So that he committed persecution by that, but at the same time, the appeals chamber decided that Mr. Sessions substantially contributed to the conduct of the perpetrators, thereby instigating the crimes of persecution, deportation, and other inhumane acts. So you see the same speeches lead to two rather different counts in the indictment. The one committing a crime himself, persecution, and the other one is instigating the crimes I just mentioned. So, and for judges, it's very important to have clear and good indictments before them, because otherwise they are easily lost. But it's not only the formulation of the indictment, it's also evidentiary questions that will arise. And some of them, and to that extent, it's an easy, I can't say crime because hate speech is not a crime, but often a hate speech inspired indictment often gives an easy way as far as the evidence is concerned. Public speeches are often recorded. That makes life really very easy, because you just look at the recording and you know what has been said, of course, unless it has been one way or another manipulated, perhaps by AI, I don't know, but we'll learn. But also the way in which the words are uttered. Often, you raise your voice, or the way in which you speak is also one of the elements of which relevant for cases involving hate speech. You say, I'm not saying hate speech cases, I'm saying cases involving hate speech. The size of the audience is often also recorded. And that can be important for establishing the impact of hate speech. And as we saw, hate speech, think about the sexual speeches, what is the impact, what are others doing, and the events following hate speech. How long after the speech people acted, or were the consequences of what the hate speaker said become known. Another matter is, and there it becomes already a bit more difficult, is the hate speech really what caused the events after that, or were there other reasons, or had it started already before the hate speaker did his act? So therefore, it's not the facts usually which are, from an evidentiary point of view, are so difficult, but rather the interpretation of the facts. And then, of course, we come also to questions like, were the words such that they incited to violence? I mean, a bit of an intelligent writer can write without any incitement to specific acts, but nevertheless, the suggestion can be very strong. Of course, if Mr. Wilders, again, I'm not saying that this was a hate speech charge, but he said, do you want more or less Moroccans? I mean, it's just receiving information from the audience, whether they would like to have more or less. And of course, that doesn't say anything. What I'm saying is that it's not always easy to interpret the language in such a way that you can draw clear conclusions. How direct was the incitement? Did the accused have the necessary mens rea? And that, of course, depends on what mens rea is required for the crime which he may have incited or which he may have instigated. If a person calls for violent action which was at risk to cause the destruction of a group, did the accused also have the necessary genocidal intent to make that incitement to genocide? I mean, to incite to violence doesn't mean yet that you do that with intent to, with genocidal intent yourself. So these are, the facts are relatively simple. The interpretation of what was said and what it legally means is often far more difficult. It's a large area that still has to be explored, and it's a very sensitive area. To draw the line between the freedom of expression and the prevention of discrimination and violence is not easy to draw. We see in these days that legal, very broad texts serve as an instrument to silence the opposition, charging them with offenses against public order, even defending those accused of, those who are defending the accused of so-called rebellious speech are at risk of being prosecuted themselves. It is of great democratic importance to very, very carefully handle hate speech, whatever it is. Do not too easily consider that there are good reasons to restrict freedom of expression, but also be not naive as to what the consequences of hate speech can be. Thank you.
Thank you all for those interventions, very interesting and very different. I wonder, James, whether you can let me know how we are doing with time. 8:45, so I think we had a couple of interesting points and questions by the panel members, but maybe I will address them offline so that we get some questions from the audience. Thank you. So, any questions or interventions, please?
Thank you. I'm Khalid Ahmed Chaudhry.
Excuse me?
My name is Khalid Ahmed Chaudhry.
Yes, thank you.
Judge Alphons Orie, you mentioned Mr. Wilders. He has been rewarded by an overwhelming majority of the Dutch voters on his hate speeches, demonization of Islam and Muslims. While in Netherlands, according to the criminal law, Article 135, C and B, hate speech is forbidden. According to all definitions of the hate speech, Mr. Wilders have been violating this law. So most probably he or someone from his party is going to become Prime Minister of Netherlands. So my question to you and the others as well, if according to the penal code of Netherlands, this has been hate speech, but the gentleman or his party is violating that. Not only him, but Marie Le Pen and some other ultra-right wingers within the European Union, they are being rewarded by according to their speeches on hate. So any possibility that these people are Mr. Wilders will be brought to justice and punished? Thank you.
Well, I think the articles you mentioned are not articles. Hate speech, as I said before, it pops up everywhere. If you want to call it hate speech, fine. You may have noticed that I am rather skeptical about Mr. Wilders and the way in which he expressed himself in public. But I think it's discrimination rather that he was prosecuted for, and not for hate speech. Again, hate speech or a speech in which unpleasant things are said. But finally, I only mentioned Mr. Wilders because I said it also exists in domestic law, but we are focusing on international law this evening. But that it's a problem, that's fine. And Mr. Chowdhury, I think we have met 15, 20 times at meetings like this one. And I'm so happy that you did not break the tradition of putting the first question. Thank you.
Thank you. My name is James Cass. I was wondering about an issue that was slightly brought up by the second speaker, namely the collateral damage we have by this concentration or over-enthusiasm with hate speech, because we begin to have a certain amount of impending censorship of the press as a result, where journalists are afraid to write something that could be considered hate speech. And then you have related discrimination. There are professors in Canada and the States who have lost their jobs because they did not quite agree with some of the neoliberal identity association and ideologies. They didn't have the means to go to court, so they just lost their jobs. Not everybody can go to court and spend hundreds of thousands defending themselves. There are people who have been fired from their jobs because they have entered in a blog something that is, in a sense, could be interpreted as hate speech, but probably, according to your speech, Ms. Fino, would not come out as hate speech, but one could exaggerate the meaning. So we are having all this happening, and we are beginning to lose a certain amount of free speech as a result, and people are actually suffering from losing jobs, even though they are not brought to trial or being accused, because it takes too long for them to defend themselves. I think I'll stop at this point. There are many other.
Yeah, thank you for that question. Very interesting. I think I will give this a go. It's very important not to be naive, and human rights treaty bodies and special rapporteurs have always noted, whenever they draw up any report or come up with a communication that is a decision on hate speech related violations, that hate speech legislation is actually abused mostly by autocratic governments. So let's not be naive. Let's be careful here. What my research is about atrocity crimes, the most serious crimes of all humanity. And that does not mean that any speech that is said within, say, an area, time of war, or in times of political violence or electoral campaign, like Wilders, he said what he said in an electoral campaign, that all of that should be criminalized. That's why I actually started with a list of the factors that legislators, prosecutors need to make to assess if it is serious enough. It's important to underline here, also given Judge Orie's point of view, is also that even human rights law, which is, as I've said, very progressive and very much eager to have a hate speech strategy, actually, worldwide strategy, has and keeps repeating that it's only the most extreme forms of hate speech, the most serious, that should be criminalized. Other forms of hate speech should be sanctioned by civil law, administrative law, maybe the employment cases you may have. I don't know if there is recourse. There should be if it's a democratic country for those being kicked out of their jobs, and very importantly, education for tolerance. So I'm focusing on the most extreme tool that a state has to counter hate speech. I'm focusing on the criminal law. It's the strongest, but there's so much more. And actually, although I consider myself a criminal lawyer, I really believe that it's the power of education that will accept differences between us that we should actually use to lower these tensions among us and these prejudices. So yeah, that is important. And thank you for the question. Let's be clear. Freedom of expression is very important, but on the other hand, let's not forget that the human rights treaties and the Geneva Conventions were born out of the violence, both of speech and of action, that the Second World War brought to us. And we do live in dark days. So let's try and use the law as we have it and make sure that speech does not incite. Thank you.
Hi, I'm Dennis McCall-Dirisu. I would like to ask, how would you qualify Putin's 11-page essay that he wrote before the war, basically denying Ukraine's existence, saying that it is a gift by Lenin, and et cetera, and et cetera. I don't need to go in detail, because it was before the full-scale invasion. However, there was an 8-year period of conflict also in the Donbass region. How would you qualify this? And would it go somewhere between hate speech and incitement, or is there any other, also, how would you consider it within the 3 frameworks of international human rights law, international criminal law, and IHL? Thank you.
Shall we get at the other questions before we answer?
Thank you. I'll be quick. Iva Vukušić, Utrecht University. I don't know how many, and this is for everyone at the panel. I don't know how many of you have potentially followed the proceedings at the ICJ last week between South Africa and Israel, or maybe even read the application from South Africa. I think from page 59 onwards, several quotes are listed. And of course, I'm not asking you to make determination, is this genocidal speech or not? But I'm just curious as to what you make of some of the arguments that you may have come across that were made by both South Africa and Israel. Thank you.
I think I've the wrong answer. I haven't read it, and from my position, I always would like to know what I'm talking about in detail before, on such sensitive issues, I give any comment. The same is true for Mr. Putin's publication. Sometimes it's better not to read it. I remember that Judge Parker, one of my former colleagues, was recused by Mr. Sechel, because Mr. Sechel wrote a book about every judge that would deal with his case. And then he claimed that he wrote such horrible things about the judge that the judge could not be impartial anymore and therefore had to recuse himself. Judge Parker responded, I'll never forget, a very short line. I did not read that book. I do not intend to read it. I can tell you I intend to read the things you quoted, but I haven't read them yet.
I'll jump into this discussion regarding this Putin's essay, which is actually not the only one, and in combination, of course, with the statements by Lavrov, by the press secretary of the Foreign Affairs, Medvedev's famous tweets. But for me, the question is conceptually. Again, I'm not in public international law. I'm talking like from the perspective of comparative criminal or constitutional law. For me, it's not even clear whether we need, because of course, and I agree with this whole debate about denial of the agency to Ukrainians, this whole Великая Россия and объединение земель русских, all this narrative that Russia is just collecting what belongs to it, whether there is no single doubt. It's almost a trivial even to ask about this, whether we have the crime of aggression, whether we have preparation of war. In one way or another, we have something of the atrocious nature. But then conceptually, the question is whether in order in the future to prosecute, let's say, not only Putin, but the whole machinery of the propaganda, because what is important is not that this essay, but the propaganda of all of those wonderful Solovyov, Kiselyovs and other major agents of the Russian TV retranslating all of that in the best traditions of Goebbels for the last 15 years. Whether this is sufficient to raise something like hate speech, incitement of hatred, but do we even need this? Even the Russian criminal code itself, there is the crime of inciting the war of aggression. So there is aggression, and then it can be read in all the interpretation as incitement of aggression. So even according to the national criminal, and then brought as the interpretive tool to some sort of international criminal court or tribunal in one way or another, I think it should be read in combination. And for me, the question is whether hate speech as such is even needed. But what is interesting for hate speech, and again, this deals with my research on intensification of hate speech, regulation and usage by the courts in Central and Eastern Europe, in particular in the context of the Russian military aggression in Ukraine, and how the provision of hate speech has been almost dormant, let's say throughout 90s, especially in the Yeltsin's epoch, around 2000, beginning of 2000s, even in the Medvedev's epoch, and how it has been boosted since the annexation of Crimea and the invention of Donbass, essentially in Ukraine. And of course, after February 2022. So basically now every second political conviction deals either with the provision of hate speech in the criminal code of Russia, or another intensification that deals more with the historical discussion, this whole idea brought into the criminal code of the Russian Federation in 2014, that the denial of the glorious past of the world, of what Russians call, of course, Great Patriotic War, and the diminishing role of the Red Army in the liberation of Europe. Let's say under this clause, for example, the things like saying openly that the USSR started the war together with the Nazis in 1939 is basically interpreted as part of this criminal article. So something as very historicized, let's put it loi mémorielle for the absence of the better term for this provision in the criminal code. Those two provisions, like hate speech and this historicized attitude of criminal code to the Russian Soviet military past, have been triple, so to say, in use since February 2022. And by the way, the same story can be observed in Belarus. So Russia is definitely not, I'm talking about the co-aggressor state nearby. The story is almost simultaneous. So for me, the hate speech there, and again, maybe precisely because I'm not thinking in the categories of the future prosecution, public international law, or the story is way more interesting on the level of the criminal law, because I suspect that all the publications of Putin and the Russian Foreign Ministry in combination with this whole propaganda machinery will be sufficient for the crime of aggression. For this, not even incitement to hatred is needed as separate crime, so to say. But again, maybe I'm saying something that doesn't make sense. Thank you.
I'll try to be brief and respond to both of your questions. As for Putin's speech, in theory, your question addresses the core of my argument. So how do we treat a speech like that or a set of speeches like that? Can we categorize them as a type of inchoate crime? So something that may have happened in some point of time much before the physical act was actually committed, in which case we would consider this as probably an important piece of mens rea evidence in a case brought against someone, anyone, any leader, any speaker at that level, certainly within the framework of the crime that has already been committed. Now, would anyone want to prosecute a political leader for an essay or a single speech or even a set of speeches as, like I said, a form of propaganda for war as, again, incitement to a war of aggression? Well, that would put judges in a very difficult position, I guess, to determine whether a single speech or utterance could be prosecuted. In theory, probably yes. In practice, I don't believe anybody would do that. There are theoretical and practical matters at hand here. So I guess that not only that speech, and I'm glad you mentioned this is not the only speech. I have a bag full of evidence, by the way, here of not only Putin's speeches, but speeches of his propagandist political military leaders, top down, as a matter of fact. Would that be sufficient? Well, it's a sum of facts, and it has to be seen as a totality of evidence. We have the crime, so a future court, I'm not sure which one now and where, would be in the position to determine and weigh the validity and quality of that evidence coming from Putin or his propagandists. So, and as for your question in terms of genocidal intent, in fact, that I think was implied in the question, or was again, it is a very similar answer to the same question. Let me put it this way. Under the Genocide Convention, we have three inchoate crimes: attempt, conspiracy, and direct and public incitement to commit genocide. Direct and public incitement to commit genocide has never been tried in and of itself, separately, as a crime. Speeches all over the world on a daily basis by political leaders, military leaders, and yet this crime has never been tried in by any of international tribunals. It has been incorporated into the ICTR cases as, you help me, as what? As a substantive crime, or maybe a mode of liability or something. This crime has in fact been tried by the Canadian court. Leon Mugesera, a local Rwandan historian, gave a speech, if the memory serves me right, in November 1992 in Rwanda, in a small village, in front of a crowd of 1,000 people. So that would be about a year and a half prior to the outbreak, the genocide in Rwanda. And he was convicted for that. It was a different type of case, different legal framework, but it was essentially direct and public incitement to commit genocide. None of the international courts have ever considered it seriously. And if I look at my my friends and colleagues, I believe that there are many reasons why no one would go forward with a case like that, but one reason strikes me as the most realistic one. No prosecutor wants to lose the case. And this would be a very, based on a very solid ground, basically, of losing the case, and only Judge Orie could tell us how he would make his determination in a case like that, where you have a single speech, which, like in Mugesera's case, was clear hate speech and incitement to genocide. And yet, no physical crime has been committed yet. So how would it?
But then we come to, I think Audrey wrote down that it's very contextual.
Yeah.
I mean, if it's only one speech, that would not exclude me from conviction, perhaps, but then I need a lot more than that own speech, that one and only speech. I mean, I might need written articles somewhere, or a program of a party which supports what he said in that one speech. So it's just the words, although even if it's not there, one speech could, but then you have to look at how the words were spoken, what was exactly said, how much it aimed at violence. So, as judges always say, it depends on the circumstances of the case.
And it's credibility also, right? How much credibility one gives to a piece of evidence, and how convincing one finds it.
Yes, credibility in of what exactly? Credibility
of what he's saying, because there are instances when they say one thing, but they mean another. For example, I'm thinking of joint criminal enterprise in Mladic. He
Yes.
said sometimes something, but then the
Yes,
trial
but
chamber.
Now we are dealing with two concepts of credibility. Do we believe that he said it, or do we believe that he said what he meant?
Exactly.
And these are two concepts of the two parts of the concept of credibility. The one is more evidentiary one, and the other one is more
to
the
answer the
substance,
questions there. Yeah, maybe just want to add one thing and we stop here. To what Predrag said, the International Tribunal for Rwanda actually convicted Nahimana and Ngeze, who was the editor of the Kangura journal that published this hate speech, on both direct and public incitement and genocide. But what we find is that all charges and convictions on direct and public genocide were always followed, unfortunately, by an actual genocide taking place, the Rwanda genocide. What we now see in the South Africa-Israel case is somewhat different, because, thank God, hopefully, there is still no genocide there. So that could be interesting from a genocidal law research point of view. But that's my opinion. I haven't read all the submissions. I did read the transcript of the South African and the Israeli positions there. So it will be interesting to see. But what is interesting for me is also, is it sufficient for just the preliminary measures to be given by the International Criminal Court? The standard is not beyond reasonable doubt that we need at a criminal law level, but it is just plausibility that this could be incitement to genocide, and also that it is a risk. There's a real risk that genocide may follow. So that is different. Thank you for your attention. Thank you to the USR for hosting this event, and have a lovely evening.